Thank you all for coming. I appreciate that. My name is Jackie Simmons, and I am the case coordinator for the MDC review teams in Douglas and Sarpy County. And at the treatment team, we see a lot of cases that have either languished in the system for a long time, or they're just coming in, but you can tell from the beginning that the permanency objective of reunification is probably not the best direction for the case. So the permanency review hearings are of particular interest to me, partly because I don't know a lot about them, but partly because I think a lot can be done, a lot more can be done than is done now on a lot of these cases. So we're going to talk about that this morning. And I want to introduce to you retired Judge Joanne Brown. She's a consultant for the National Child Welfare Research Center on Legal and Judicial Issues and the Institute of Law and Public Policy and Mark Morrison Associates. Trained as an attorney and a social worker, I really like her. She's a member of the bar of the Supreme Court of the United States, California, New Mexico, and Maryland state courts, and the U.S. District Court of California, New Mexico. Somebody asked where she was from, and it's like, it's kind of hard to tell. Let her put that in. She served as general counsel to the State of New Mexico Department of Children, Family, Youth and Family, and the commissioner for the Alameda, I meant to ask you how that was pronounced, County, California Superior Court. So please help me walk.
So good morning. Thank you all for coming and for participating in this really impressive conference. I was talking to Vicki Weiss a number of times over the last couple of months. I'm presuming, one of the questions, can you hear me back there? I never know how people answer that. If you can't hear me, you can't hear the question. It's sort of odd to me. And she said, oh, just a few people from Nebraska. Just a few people. What's that, Vicki? Oh, I don't know. You know, we've got these teams around the state, and judges leading their teams, and we've been working on this for a couple of years. And so then I get this email, and she says, oh, it's about 400 people. I said, that's a few people, right? So I am just, this is a very good I'm very impressed. I see a lot of conferences. This is well attended, well organized, and you have a tremendous diversity of subject matter here, all of which are on topical issues. And I think that those of you who got up early enough to listen to Howard Davidson this morning, my colleague from the ABA, talked about fostering connections. You have listened to a description of and an analysis of, I think, some of the most significant child welfare law that we've seen. I think of it as really cleanup law, and I'm not going to go into any detail about it, but I will reference it in certain points as we go through talking about permanency hearings today and what's a meaningful permanency hearing. Because it looks to me, and from the few conversations I've had here this morning and yesterday, and talking to Vicki, that we really have practitioners in this field, be they lawyers, judges, social workers, providers, they're really experienced. And so I'm going to focus on a couple of, in my experience, tough issues, and I think they may, I hope they resonate here. If they don't, then let me know, and we'll emphasize another piece. But one is going to be family involvement in case planning and the whole case planning process, and how that's an advocacy tool, and what judicial oversight in terms of case planning might look like, and what kind of questions really will tease out the issues, at least in my opinion, experience, and best practices that really lead to good decision making and meaningful permanency results. And secondly, I'm going to talk about older youth. And when I talk about older youth, I'm going to use the Children's Bureau operating definition. Come on down, there's plenty of room. Nobody bites up here, we're all friendly, you know everybody. Yeah, it's all Midwestern folks, they're all nice. We got lots of preferred seating in front, of course. Get out of the way. So, older youth. What do people think that older youth is? And I won't ask you because I just walked up on you. What do you think when I talk about older youth? Okay, and what's the Children's Bureau operating definition of older youth? What do you think of older youth? What do you think of older? Now, we're not old, we're not going to old today. We're talking about older youth, older kids. Give me some numbers. What's an older kid in your mind? 15. Say again? 15. Some other numbers? 12. 14. Okay. Any other numbers? Come on.
13 to 16?
13 to 16. Oh, she's good. No, you're wrong. We don't get to answer any more questions. Henry told me he was on the guidelines committee to develop the original guidelines on practice in this area. It is 10, it is generally 10, and most recently with the CFSR data that's coming in, they're looking at 8. Okay? So 8, remember 8? We have 8 years old who, you know, who like this and some like this. We also have an 8-year-old who probably could crawl under that table very easily, and would probably like to. Older youth, that's older kids, 8 years old. And why is that significant? It's significant because that's the statistically, and we're between 8 and 10 here. Okay, we're probably moving towards 8, but 10's been really what's researched. That is the statistically significant age at which your likelihood of getting adopted goes down. It doesn't just kind of wobble down, it goes down. Okay? So when I talk about older, and I'll say older youth or older kids, remember, I'm really talking about anything post-8, but research-based post-10. So think about that. We're not talking about teenagers. I'll talk a little bit about teenagers, but we're not talking about that sort of troublesome, engaging, delightful, frustrating group of teenagers that we all once were, and we all sort of have. It's a challenging population. It's challenging to be a teenager and challenging to work with them. And we're talking about 8-year-olds, 9-year-olds, 10-year-olds. They're not even in middle school. So those two areas I'm really going to focus on when we talk about improving permanency and meaningful permanency hearing. From advocacy perspectives and subject matter area. One is going to be case planning and one's going to be older youth. So I want also not to forget, you don't have a bright yellow one, but it's my top 10. Okay? This is my top 10 as of, should have been the end of August. So I'm not held to this top 10. I may have a different top 10 the next time you see me, but there are 4 references here, and I'm sure most of them are familiar. You could have him autograph this. She has the resource guidelines. So these are my top 10. I think most of them will continue to be my top 10, but I'm always going to give you good resources. My top 10, top 10, top 10, 1, 1, 1, 1, 1, number 1 is the new consolidated gateway for child welfare information. And when I say child welfare information, I mean everything. I mean law, I mean policy, I mean regs, I mean state information, I mean funding opportunities, I mean the child welfare practice manual, which if you don't know about the child welfare practice manual, and I'm speaking specifically as to lawyers, but I know the child welfare workers and providers do, then you need to look at it. And you need to go on to www.childwelfare.gov and plug in Child Welfare Practice Manual. It is a Q&A. It's an FAQ format. So for every federal child welfare law, I shouldn't say every, the vast majority of the child welfare laws that relate to the work that we do in around abuse and neglect, you will find question, come on, Ted, there's room, the question and answer format. Questions that real life people, have written in and sent to the Children's Bureau asking about interpretations of various parts of the statute or the regs. And after you have this question, you'll see that the question is in very real terms, real language. You'll see a real language answer. What a novel idea. A real language answer. Okay, so it will give you, not too long, maybe sort of medium paragraph sometimes, maybe a little bit less. It'll also give you references. So if you want to go dig deeper into the reg, or dig deeper into the federal law, or look at a research reference, that's also there. But it's hard for me to understand how anybody practicing this field would not find this reference to be really useful. It tells you what the standard of practice is. When you're cross-examining the social worker, when you're cross-examining an expert, when you're arguing reasonable efforts, the ability to be able to say, Child Welfare Practice Manual, Section 42, defines reasonable efforts as, defines compelling reason as, defines diligent search in terms of a parent as. I mean, that's what we do as lawyers. We have the law, we find a definition, we try to get around it. But the bottom line is, you got to know what it is before you advocate. And sometimes our job is not only to educate ourselves and our clients, but to try to educate the rest of the legal community. And sometimes it's a challenge. Okay, so I'm really suggesting to you that if you look at nothing else, you make that make this website and child welfare, the Child Welfare Practice Manual, part of your, those magnets that you put in your refrigerator, that kind of easy accessibility. We have the National Resource Centers. Ours here, the ABA number 6, continues to expand. There's an education website. There's a parents, attorneys representing parents, listserv and web page separate from that with tremendous resources. For research, I always go to Chapin Hall, Chapin Hall, Chapin Hall, Chapin Hall. Not only does it have on its website its own good research in this field, and they really do, in my opinion, really solid research, but they're a good collection source for research results from other states. And there's a tremendous amount of research out there on everything from impact of removal to risk and safety to visitation and visitation planning to parenting. I like her reframing that yesterday as parenting time coming from the family law, to impact of smoking in a family, to drug abuse and the extent to which drug abuse should be a grounds for removal or not removal, or grounds for reunification or not for reunification. Long-term foster care, the impact on kids, what we used to call long-term foster care, kids transitioning out. One of the most interesting studies that came out recently, and within this year that you should look at, has to do with reunification. And what is the statistically significant factor in reunification for this population? I don't think it was just Chicago. I think it was a bigger population outside of the urban area. What they found to be the most statistically significant condition for reunification, in the sense of the recommendation for reunification and then the court following through with that recommendation, was not what I thought it would be. And this is a sort of your typical, unfortunately typical, single mom, drug abusing, constellation of socioeconomic problems associated with that. We could all write that scenario, unfortunately. What came out to be the most statistically significant factor in whether or not there was A, a recommendation for reunification, and B, whether the court followed it, was not whether the mom was sober, or clean and sober, whatever language we use. Was not whether there was, she had a job or had a house or sort of some of those other factors that we often, or completed her case plan, the checklist case plan, What was statistically significant, the only thing, was whether the social worker believed that the mom could provide a safe environment for that youngster. And how did she make that determination? She made that determination based on watching that mother visit with her child or having her child in her home and watch the two of them together. Watched how the mother interacted with that child, watched how the mother took responsibility for and was able to manage the other household responsibilities, possibly other children, because it was a wide sample. The only statistically significant in this study, there are other studies, but this is the most current and I think a valid study from what I can tell. The statistically significant factor was that opinion of that child welfare worker, that social worker, about this mom based on observations in the home. Not based on 1 hour a week, in a box somewhere. Not based on watching the child and the mother interact in the stranger's house. And I was in Alabama and I was talking to attorneys and social workers and judges about a variety of topics, and I realized that I kept saying foster home. And we all in this field call it a foster home, and that's the proper label, and there's statutory authority and language in many states around what a foster home is, and there's regulations, blah, blah, blah. But for a youngster, however old that child is, from an infant, as far as an infant processes a label, up to teenagers, these are stranger homes. And I love foster parents. I'm a real fan of where foster parenting is going and the courage and the commitment of foster parents. Do you have any foster parents in here? Yay! Okay. Thank you. Thank you. So it's not that. It is that to that child. That is a stranger. No matter how warm, how supportive, how inviting, how engaging, how much they go out of their way, that is a stranger home. So when we think about judging parenting based on judging some parenting skills based on observations occurring in the stranger home. Just want us to be mindful that we're not, it's not an even, it's not a level playing field. I know we don't like to do that. It's one way, one of many factors we take into consideration in assessing compliance with the case plan or assessing readiness for a child to be returned. But just keep in mind, this is a stranger home, and that will, regardless of how great the foster parent is, for X amount of time, and maybe in some ways, fundamentally forever, it's a stranger home. Okay, number 10, you've heard some workshops. I don't know if you've attended, excuse me for turning my back on you, but there's a whole big effort to really talk about father engagement, fatherhood. And there's some materials on one of the tables on the left-hand side here that I really suggest you pick up. There's the quality improvement website, and you also, I think you have speakers on that, or a speaker on engaging fathers. In addition to it being a really good idea and research-based in terms of reunification, it's also one of the 2 reasons that cases, TPR cases, get overturned most frequently. Overturned most frequently in states. Failure to prove diligent efforts to serve and serve properly father. And the second is ICWA violations. Okay, permanency. I'm going to talk about our roles and challenges in permanency, and not just in the context of, let's see if this screen does work. Okay, not just in the context of a meaningful permanency hearing, though everything I say is going to be within the context of getting where we really want to go and where we're supposed to be focusing on in terms of the work that we do. So I'll talk about advocacy issues and practice pointers and what I consider to be meaningful permanency hearings as we go along. But just remembering what's permanency. These are some of the questions that we'll talk about today, this morning. This is not helping me here. Hello. It likes this one page. I don't know why. Hello. Okay, so technical guys are going to have to do while I talk. We're going to talk about permanency as a concept rooted in child development and its relation to the law. We're going to talk about what works and doesn't work. I've already told you that we're going to focus on 2 different issues related to that: case planning, how that is a roadmap for all of us, and particularly, and specifically for judges. It should be done so well and developed so well. Thank you, you have the magic touch. And developed so well that when you get to the end of that permanency hearing, there are no surprises. There are no surprises. And the judge isn't surprised either, which is a good thing. That case plan has been so well developed. The parents have been engaged. The relatives have been sought out. The case plan has been updated. The attorneys have worked with their clients to make sure that their needs are being met and the services they're receiving them timely. That there is no doubt at the permanency hearing what the judge's determination of the fact in his or her application of the law should be. That's my standard for a case plan. It's open, everybody knows about it, everybody's engaged. It's current, and it meets the fundamental requirement of remediating, or attempting to, sometimes you can't, remediating those circumstances that allow that cause that child to be removed. And we're going to talk about challenges to our roles, and we're going to talk about this foundational principle. I don't know that we think about it in this way. We probably think about it in a lot of different ways, but that's really what we want to get to. We want to get to a place where a child can be in a home like the home that we like for our own children. Now, and it's a right. It truly is a right. And if we keep it in our mind as a right, I think it helps me at least to make sure that I keep children in the forefront. So it's a right to have a healthy and safe childhood, youthhood, teenagehood, personhood, in a nurturing family or the closest possible setting. So what do I understand permanency to be in a sentence? This is my sentence. You may feel free to use it. Okay? It is a psychological state implying security, identity, and connection without limitation. here's some dimensions of it as I see it, but let me talk to you about it in some terms that make it meaningful to me. And I think we need to talk about permanency because we toss it around a lot. Okay? So I think about permanency in the context of the first line here, which is the opportunity to live in a safe and nurturing home environment which can be returned to for support even when you're an adult. It's going home after your first year in college at Thanksgiving. Okay? Your room may not exactly be the same way as it was because, you know, how those things happen, okay? But you probably get to use the remote. The dog probably still recognizes you, and the cat doesn't care. There's stuff around that's familiar. You know, your stuff is still there. Maybe put away a little bit, and maybe orderly your room, maybe clean her up. You know, or it may have been another guest room. But in any event, it is a sense that you can come there. You don't have to, in whatever sort of emotional, physical condition that the welcome wagon, the sign is on the door. However you translate that into working with your clients, that's what we're really struggling for. That's what youngsters did not have and why they had to be removed from their parents. It's a sense of belonging and a definitive social status. I've been struggling with that concept because it often comes up when we talk in the research field from the psychologist about why that legal social status is important. This is what's helped me understand that. And the example is this. When you have research that shows to you, that tells you that youngsters aging out of foster care, when asked to report who is the most enduring or most stable person in their lives up to that date, where they're 18, 19, 20, 21, and they give the name of their social worker, that's not a good thing. That is truly not a good thing. It's really wonderful that they have this good relationship and the fact that they have this connection will something will allow them to bond, I firmly believe, will allow them to establish equivalent good connections over life. That's wonderful. It's practice. It's wonderful. I'm sure the social worker do good things. I'm not going there. Where I'm going to is if that's all we've done, a person who is paid, and I know you don't get paid enough, and I know that you don't do it for the pay, all those things, okay, all those things aside, if the person that child who's aging out of foster care, who's been in our care, who didn't want to come to us, didn't invite us into his or her life, okay? And we appeared one day and that was it. If that's all that we've given that person, as good as that relationship could be, we haven't done our job, in my opinion. And so a sense of belonging and a definitive legal status relates to that. I am someone's son, I am someone's daughter, they are my guardian, they are my parent, even though they are not my parent in terms of the law, or they may be that person who gets to sign all those paperwork. I have an address that I can always use. All that goes into the sense of permanency. Okay, constitutional analysis is about law. There is only one reason that we as a society are able to intervene in a family. Family rights, we all know, quick mini refresher here. The right of parenting is a liberty interest from the 14th Amendment and to some extent from the 5th Amendment. Okay? It's a liberty interest. That's like life, liberty, and pursuit of happiness kind of interest. It is a fundamental constitutional right to make decisions about your child and to effectively control who he sees, who she sees, what they wear, what they eat, where they live, where they go to school, who their doctors are. All those decisions as parents we take for granted are protected by the Constitution. At some point, that gets trumped by the fact that we're doing a miserable job about that. We're putting that child at risk. And that child is so far at risk, because there's always risks, that that child's unsafe continuing in our care. Only when we get to that factual point where that child is unsafe in our care, and we have the evidence it's contrary to welfare, there's no other way, there's no reasonable efforts that we can use to remediate those conditions without removal. Only at that point do the rights of the state trump the liberty rights of parents. So I remind attorneys all the time, when you're representing parents, you're talking about constitutional rights here. It's not just that, you know, these parents need an attorney and I'm going to represent them and I'm going to do my best. We're talking about their constitutional rights to make decisions about their child. I can't think of anything more profound except for the right to live or die, possibly. But I want us to keep that in the nexus. I think it elevates our sense of practice and what we do in this field, and I think sometimes we get, maybe not Nebraska, kind of robotic about it. Yeah, tech people, you know. Okay, so I put this slide and I apologize for it because I was incorrect when I did it. I put a decade of seeking permanency. It ain't a decade. And I thought, oh, it's 2 decades. It ain't 2 decades. And we're almost into 3. Come on. Okay. So, federal child welfare law. All of these are critical pieces of the infrastructure that gets to having meaningful permanency hearings. Okay, they relate to all of our roles in here to some extent or the other. They're all laws that you should all be familiar with. I continue to learn and read through these laws. The Adoption Assistance and Child Welfare Act of 1980 is where we first see case plans. And I went back to when I was doing some work in Florida last week with judges around family engagement and good elements of good case planning. And I went to find where did this at first in federal law, the term case plan, come up. And there may be some other previous references that I didn't find. But this 1980 law, not only does it talk about case planning, which is a standard component of good child welfare, but it talked about parental involvement and involving children in the case planning. So we have CAPTA, which requires that a JL be appointed for each child. We have ASPA, which reminds us all while we're here to some extent. And you've heard about fostering connections. What's interesting about CAPTA is that all of a sudden there's a heightened attention to the role of the attorney in the court. There were, of course, everybody knew, and the federal laws talk about judicial process. But with CAPTA, all of a sudden, from the Children's Bureau side and from the national legislature's side, we're really looking at how do we guarantee basically minimum due process across all the states? How do we have a certain level of judicial management, is not the right word, a certain level of judicial justice, if you will, across the states, guaranteed to all children and families, and a certain level of competency and protection of rights. That's where we begin to get a real emphasis on the judicial and the court side, whether it's through requiring a GAL or attorney to be appointed every child, or whether it's requiring training for judging attorneys, whether it's requiring specific areas to be developed, whether it's specific, more detailed regulation. So we have a real foundation in the law for the work that we're doing and for the requirement that we do it in a meaningful way. Okay, so how does permanency translate? Okay, I think I have my assistant here. A meaningful permanency hearing has a lot of ingredients, and a pitch that I'm going to make is case planning is a key to it. I've talked about that. I'll talk some more about it. But a related pitch is preparation is the key. If you do not have a meaningful case plan, which means participation of parents and extended family members and the youth in that it really does link each service discreetly to the reasons why removal was necessary and to behaviors that will evidence that those reasons or those circumstances have been remediated. You don't have a good case plan. Assuming that you do, it has to be updated constantly. One of the CFSR conclusions here in Nebraska, which is not uncommon at all, as you might imagine this day and age, is inadequate services. Your service array is insufficient according to these federal CFSR standards. I think we'd all want as many possible services as we could, and it's inconsistent between rural and urban, which is true nationally. Trust me, it's true nationally. And it's one of the big, in my mind, the real tragedies of the work that we do. So if there is preparation, the next key, and the preparation includes good case planning. The next key is looking at your first hearing, your 6-month hearing. Now, you may have earlier hearings in Nebraska, which is great, because that means you're able to keep on top of it. You build the effectiveness of your case plan, you build the effectiveness of your permanency recommendations, and you create more meaning, or you add more meaning to the decisions the court will have to make at that 12-month permanency hearing by how well you have monitored that case plan as it goes along. So these principles are principles that really guide, as I would say, our preparation in terms of advocacy and in terms of social work practice till we get to the permanency hearing. Okay. So what's good case planning? I've talked a little bit about the context of a roadmap, and I think that is a viable reference point. So how well do we do in terms of case planning? That's how well we do. Now, there have only been 32 states. By my math, that's already the majority. We're poking up towards 2/3, okay? So 32 states. I'm working with a couple of states that have the CFSRs coming up. One just had the exit interview on Friday. That state is going to make 33 on that list. I understand it in many instances as incomprehensible to me. If we are doing our jobs as lawyers, those numbers should be different. Now, we can't create we can kind of create services. We can bring services to play, either through our work with our own clients or through our work with the agency to provide services. However, if we are really doing our job as attorneys, there should be no reason why there should be anything inadequate in the case plan. Because we sit down with our client, we go over the law, we look at the facts, we look at the services, we go back to the social worker. Or if you have, I know if you have a treatment team or multidisciplinary team here that's also available, if you do, that's a tremendous resource and should be used. But only if you're paying attention and only if you're engaged up front. There is no lesser standard of competency, no lesser standard of ethical competency for lawyers in this field as in any other field. There is no competency light when it comes to representing parents in abuse and neglect proceedings. There's no competency light when it comes to representing small people, let alone teenagers. There's no such thing. And in terms of being a county attorney, you know there's no competency. If we really want to have a meaningful permanency hearing, it requires, from the advocacy perspective, that you be into that case plan, because that is the document that, in addition to whatever testimonial evidence you bring ahead, that the judge is going to be looking at to make his or her decision about whether or not the parental rights of your client are going to be terminated, whether your client's going to go home, whether your client's going to go to live with a relative, whether there's going to be a guardianship. That is that critical point, and you prepare that. You prepare your ability to advocate effectively at the permanency hearing by your working on that case plan, making sure it's accurate, current, complete. There's nothing extraneous in it. It cannot be a cookie-cutter case plan. It cannot be a cookie-cutter. I know you don't do it in Nebraska, but if there is a little bit of a tendency to do one from column A and one from column B and one from column C, a parenting class, a drug class, a substance abuse training treatment class, a advanced sort of parenting skills, a little bit of dissertation over here. What else to do? Maybe some work with a medical doctor. Maybe a psychologist, maybe a counselor. If that's the way that your case plans, or you have a tendency to see case plans that look like that, it doesn't work. There's no research foundation to believe that that works. And there's only research to conclude it doesn't work. Case plan has to be linked to the reasons why the youngster was removed, period. And you have to have behavioral, there has to be behavioral measures. It's not, I went to all the classes. One of the most frustrating things for judges, and I think that's universal, is to have a parent who's completed his or her case plan, gone to all the classes, taken all the tests, done all the visits, and the social worker comes in with a recommendation that's not returned. And you say, why? Hopefully the lawyers are saying why. And hopefully it doesn't get to that point, but just hypothetically. It is really tough for a judge then to make a decision when somebody is saying to them, the agency is saying to them, out of concern for the child, no doubt, that this just somehow isn't enough. There's something else missing. Well, if it's missing, it should have been identified early on, and it would not have been missing if you really focused on the grounds for remediation and behavioral results. So look for behavior. What is the behavior that will evidence that the causes for removal have been remediated? Okay. Now, I think these are boys and girls, but maybe not. Look, last night I thought they were all girls, but I like this slide. Okay. This is in case we forget. And I take these kids with me everywhere. I thought I couldn't take them to Alabama, but they said, we can serve them in Alabama. Okay. Nebraska has 5,838 kids in out-of-home care as of March 31st of this year. 5,838. It's a lot. That's bigger than some towns. Frankly, that's probably bigger than a lot of Nebraska towns. It's certainly bigger than a lot of towns in New Mexico, I'll tell you that, and even a lot of towns in California. You have a state population that's 1.7. Almost 6,000 kids. That's a pretty, you had some ups and downs in your numbers, but that's a pretty consistent number. Okay. So, biggest challenge for kids. And that's older youth, okay? Remember? Tabletop size, or height rather, 8 years old. 50% of children in care for more than 2 years are older youth. 50% of children in care for over 2 years. 50%, half. You know, I actually tried to get numbers from Nebraska and couldn't. I'm sure they're here, but within the time I had, I wasn't able to get them. So if you figure that, you have 58, 38, so that's almost 3,000 kids. 8 and older. They're not as cuddly. You know, it's infants and adoptions, and that happens, and we're doing better about that. These are also kids who in large part have now had diagnosed issues. If we're doing well about assessment, and frankly, your CFSR results say that you're using assessments and your ability to assess here and your resources for assessment of children and families is limited. That's really a key advocacy piece in looking at the case planning. If as an attorney, you do not see a good assessment referenced in that case plan, you need to get that done. And you need to get that done by going back into court, asking for a court order, asking for an appointment to be made. If you have your own expert reviewing, then you need to bring that name forward. You need to have a solid assessment. That's a guidance along with the conditions, circumstances of removal for that case fund. If you don't have it, you're sort of irrelevant, I think, in some ways. Okay. Children this age often have diagnosed and undiagnosed emotional needs and serious emotional problems. Dual diagnosis, unfortunately, is becoming more and more recognized when we get developments. What about teens? Do we make them more trouble than we are, than they have to be? I think this is really important. I think that and I have to say I contribute to the stereotype too, and unwittingly, and I try not to do it. We know that the brain develops, okay? The brain develops. The frontal lobe does not put it all together. I'm not sure sometimes ever, but assuming that we can use research, right? And I have his name on the other slide. Dr. G-E-I-D-D at the National Institute of Health has done this incredible, very accessible research and 1,000 papers and websites on brain development. You know, we look at what areas of the brain, like the brain scan notion, okay? But he's done the research around it, and he really, really looks at incremental points in development where the brain is going. The frontal lobe, as we all know, develops and sort of hardens, if you will, finishes growing. I don't think it ever finishes growing, but mostly finishes growing last, right? So the frontal lobe is where we have judgment. It's where we have discernment. It's where we can balance things. It's where we can project from the present to the future so we don't screw things up by doing something really horrible in the present that will eliminate options for us in the future. This is what's happening with teenagers. They're not there yet. Okay? Really, I really urge you to look, if it's your caseload, if it's your client, look more closely. Talk to these kids. Talk to these kids. They are inconsistent. 9-year-old kids. I mean, come on. They're inconsistent. I hate you, I love you. I hate you, I want to go. I hate him, I love him, my best friend, not my best friend. Come on, okay? When a child says no to adoption, we have to unpack the no. It's one of my favorite terms. And that goes everywhere. GALs, you have to have such a good relationship with your client that you can really explain to him or her what adoption means. Really what it means. And find out what nonsense, or fears they have collected about that. What does it mean to them? Changing my name, not looking at, not having my brothers and sisters, not being able to go home anymore, not seeing you, what kind of stuff have they picked up? You really have to unpack that to make sure that you're really, in my opinion, you are really representing that youngster's best interest when you go to court. And I don't see how you can do that until you have this conversation. Yeah?
Let's talk about that for a second.
Okay?
One of the things I run into, particularly with females, is the ongoing proposition that mom and dad are somehow going to rematerialize, even if there's been a TPR. Got any bright ideas for diffusing that particular firecracker?
I don't think you can.
Okay, then what do I do about it?
I think you focus on helping the youngsters develop a parallel plan. Okay.
All right.
Mom and dad aren't ready. They're not ready yet. They may come in, but right in the meantime, until they're getting themselves together, you have to prepare for yourself and for your maybe siblings. Sometimes an anchor is helping your brothers and sisters. One of the things that we know research-wise too, frankly, is that youngsters transitioning out at 18 will often, statistically significant, go back to whatever biological linkage and often their parents. One of the really, I think, encouraging movements across the state in terms of statute, and I looked at your statutes, but frankly, I'm not sure if I saw it here, is a statutory authority for courts to set aside a previous termination order. So it's a reinstatement. Okay? It is, not here, okay. And it comes from that research. Now, states have specific requirements. It has to be so many years that the youngster has been in. Nationally, we often call it an APPLE, which is, we call, I think, an independent living, or it could be a reunification plan. But it's that state after, TPR, where it's just, we don't have an adoptive home yet, okay, and we don't have a guardianship. So it's that kind of what you used to call long-term foster care, I don't use it, but that's that state. What we've seen is that because of youngsters going home in some fashion, that states have decided, and it comes from lobbying from youngsters in foster care and youngsters who transitioned out. We want to be able to have that legal relationship with our parents if we choose. All the states that I know of, and I know 8, so there may be more, so hold me only to 8. The motion has to be made by the child, and the court has to make the child the teenager. It could be an adult. It could be an adult. It could be somebody over 18. Comes back to the court and says, I want my parental rights and my parents reinstated. And states have different stringent requirements or more broad requirements about what that takes. That's a reflection of that bond. That's a reflection. I don't think you're not going to win that argument. Or that persuasion. One of the reasons that we advocate, and I think of the ADA and the National Resource Center, for youngsters to come to court. Okay, how often do kids come to court here in Nebraska?
Less often than they should.
I mean, one of the 10 cases.
90% of the time in my court.
90% of the time. Okay.
What about? It depends on the judge.
Depends upon the judge. Okay, now we all know that, and you're going to hear from Andrea, and she's doing a parallel. Andrea Curry's she's going to do it again tomorrow on The Voice of the Child. Really good. It's excellent. 2006, court must consult in an age-appropriate manner with youngsters. Okay, does not require that the youngster come to court. And how do you do it age-appropriately? So it's an advocacy issue. What kids will tell you is they want to come to court. In all the CFSRs, the 32 states where now 33, CFSRs have been completed, they do stakeholder interviews, they do interviews of kids. Okay? 82% of the kids say they didn't come to court on any regular basis, 50% say they never came to court. Now that's their reporting.
So you're saying that the fact that you've got the kid coming to court gets them thinking logically about
Yeah,
the fact.
I didn't say
this is
logic, I
gonna
don't
come
know
in.
logic.
Yeah, I understood, that's why I was asking.
Let's do realistic.
Yeah, I understand.
Yes, absolutely.
I have another specific problem
And
with
I'm just
that.
saying, one of the corollaries of that is, there's an argument often that, well, you know, youngsters don't want to see their parents. We do want to see their parents.
Yeah.
But there's something to be said for their seeing that their parents are not doing what they should be doing. It's not from a punitive perspective. It's really from,
Reality.
you know, it's reality. You know, and reality is not always kind. It hasn't been kind for these kids, frankly. Yes, I'm sorry. go ahead.
No, I agree. One of the logistical problems I have in my area, which is north and west of here,
Uh-huh,
is our kids are scattered from here to Leyden.
right.
I'm going to go see a kid that's south of Minden today, tomorrow when I'm on my way home. I had to drive 8 hours round trip to Norfolk from my home base.
Wow.
Yeah, well, it presents teeny tiny problems of getting the kids to
Sure.
court.
Sure.
They have transport.
Yeah, they do. You're right.
Well, you have.
In my court, the attorney or the guardian ad litem for the child, which is the attorney, has to make a motion not to have the child there. And most of the time, at least the ones I've seen, is because
Shift the burden.
they're involved in a soccer tournament or they'd rather be at school.
Right, yeah.
Go figure.
I understand, but it's still a hurdle, and that's the
Absolutely
problem.
is. So, you know, you do surrogate measures like you do in life all the time. Can you get a letter? Can you get photographs? I've been really pushing this, and it seems like, you know, people go, oh, photographs. You know how everybody on your phone, you can take a picture of everything? Don't anybody take a picture of me and your thing. Anyway, but you put a photograph on top of your report file, or just bring it into court. Hey, judge, remember Freddie was like this? He's now like this, right? What are we doing with him still in foster care? It is really, really impactful. It truly is. I'm ashamed of myself that I didn't ask for photographs on the files of kids who didn't come to court. That's one way, you know, and get something in writing from a youngster. You know, get a picture from little kids. I mean, get a picture from little kids. There's going to be a way to bring that youngster. Can you hook up with a CASA? Can you hook up with other youngsters who might want to come to court? Can we do a road trip? I know it's really frustrating, but make that youngster's voice as real as you possibly can through visuals and through direct communication. The results are going to be better. Let's talk about some roles here. County attorneys. I think that the two key pieces of your ensuring that permanency hearing is meaningful is that you maintain good communication with your client and you have a system-wide perspective. And by system-wide, I mean if you see there are deficiencies in DHHS, if you see that workers need training, if you see that supervision is inconsistent, if you see that their caseloads are just overwhelming, you got to talk about it. You got to talk about it. I know you do. I'm just reminding you, or attempting to remind you, that that's part of your ethical obligation. It's part of your, to the state, to be the attorney for the state, if you see yourself that way, to the county, and certainly insofar as you have an obligation to be confident as an attorney, if there are impediments to the ability of your witness and of your case to be developed because of systemic issues, then you have, in my opinion, an ethical obligation to make sure that those issues are raised to the appropriate person. You have to be knowledgeable. This is a very complex field, and frankly, with the amount of information we have available and good research, it gets more and more complex. Okay, social workers. I always put this up because of the ethics. The ethics statement, the summary ethics statement from the NASW, National Association of Social Workers, is, I think, better than a lot of the ethics statements for attorneys. And I look at a lot of ethics rules around the country and canons. It says your goal is to help people address social needs and challenge social justice, challenge social injustice, and to work with people. That's really what we do. Those are lofty, though. Those are really high standards. Insofar as we do those well, insofar as you do those well, and we expect you to do those well, we have better permanency outcomes and better permanency hearings. This slide really talks about sort of the evolving family engagement and family-centered practice. It is just, I don't know where you find that family engagement here and family-centered practice in Nebraska. Is that a practice model for you? Somebody give me a nod. Yes. Okay. All right. This is what I thought everybody was doing all the time. You know, when I was on the bench, I thought this is what it was. And I didn't understand the dimensions of it, the complexity of it. But this is wonderful stuff. So insofar as we're judges, we're lawyers, we're providers, to support DHHS and their workers in attempting to really engage families, not just the parents, so the parents are critical, not just the kids, so the kids are critical and have to have a voice, but relatives, those third parties, those play cousins or aunts, those people who are always there, you know, the neighbor who's always there, the person across the street who might as well be blood because they're always invited to everything, they're always called upon to solve problems. That's family engagement. They have tremendous resources. If you are looking at a case plan, you do not see evidence that there has been regular communication between that social worker and the parent, regular communication with that youngster, including visits, face-to-face, and regular outreach with some relatives. If their names were collected at day one and you never see any reference about them again, you do not have a good case plan, you will not have a meaningful permanency hearing because important evidence and resources are being excluded. You can't come up with compelling reasons, in my opinion, if you haven't really looked at what your options are, both blood relatives and other third parties who may be willing and able and interested, if they knew, to provide permanency. Now, you know from listening to Howard this morning about the requirements on fostering from the Fostering Connections Law. About 30 days, this child welfare worker has to evidence that they have reached out to and given notice of removal to relatives. That's huge. I mean, it's a burden, I've no doubt about it, but it's huge. And for attorneys, you cannot let that go by. And you have to ask your clients, who else is there? What is your parallel permanency plan for your client? If reunification is not possible and you've had a real candid discussion with your client from day one, a respectful, candid discussion with your client, then they need to be not only working on their reunification, they need to be giving you another plan. That's called concurrent permanency plan. You can call it Plan B, Plan C, Plan D. It's what we do for our own kids. What if we're in an accident, right? Don't we plan for who's going to be the custodian, the guardian of our child? And what if your husband died, or you and your wife died, right? So that's the analogy when we meet with parents as clients. We have to talk to them about coming up with a parallel permanent plan. What is your plan B? That's what good parents do, and people by and large want to be good parents. They may know very candidly they can't do it right now. And frankly, they may know very candidly it wasn't a good idea for them to do it in the first place. But you got to have that discussion. Now, what about a GAO? We talked a little bit about it. There's Dr. Jean from NINH. You got to get that youth voice. Maybe you could teleconference. I don't know, the gentleman in the back of GAO, maybe you have teleconference abilities. Do you have that in your courtroom? Or audio? Can you have the youngster call in? Would the courts accept testimony? Anything to make that youngster real. Call, video, go down to local community college, see if you can get into the courthouse in some fashion. And that's what technology's for. Come on, let's use it. It's there. You got to make that youngster real in the courtroom. You've got to make sure that you are really understanding that youngster, his or her needs, and that they really understand the process. Because kids, and the older youth is a lot more sophisticated, I submit to you, than our youngsters. A lot more sophisticated. And they need a lot more guidance to making decisions and a lot more investment in their lives, because as much as we want to support permanency and that bond that is permanency, I think we have to have our own plan B, that the youngster is going to have to do a lot on their own. Or they're going to reconnect with relatives. In any event, we want them to be as strong as they possibly can when they leave care. Okay, remind the judge the clock is ticking. When I went on the bench, they gave me an egg timer because I was doing family law as well, and my clerk was wonderful, Jerry. She told me, she said, look, short cause actions on family law calendars are supposed to be 20 minutes, otherwise we are going to be here till Sunday. Okay, she's very clear with me. I'm not suggesting that you have an egg timer on your bench or on your counsel table. What I'm suggesting is that attorneys need to keep the pressure on in terms of attorneys for kids, and I think parents too, frankly, need to keep the pressure on the judge And make sure that they understand, both at the periodic 6-month reviews and any other time, that you get to go to the court and make this child real, that this child's getting older. We're all getting older, but this child really is getting older, and very quickly. Okay. You need to have good communication skills. And you need to remember that as you have an older youth client, their world is expanding. So there may be more meaningful adults in their life today than there were yesterday. I hope so. I hope so. So constantly ask your client, is there somebody else in your life who might want to come forward and either be, a guardian, a foster parent, somebody you'd like? Who do you choose? Where would you like to live? And let me see if we can have that conversation. Thank you. So there are just so many more options, but we have to be really creative in working with older youth. And what about the permanency hearing? Do they want to testify in court? And if so, you have to prepare them to do so. And how do you testify? In court, they testify on camera. So many variations of getting that youth front and center, and that child front and center where he or she should be. That's in part what a meaningful hearing, permanency hearing is about. I put CASA, do we have any CASA volunteers here? Good. Hi, thank you. Thank you for being a CASA volunteer. That's a tough role, but that's really another clear voice role. Get clarity from those youngsters, find out what their issues are, help them think through, what they know or they don't know about the process, help them be prepared to come to court. Help them think about what that might mean. Find out, if you need some help in terms of having them come to court, do they need to sort of sit in the back? Do they need kind of, come and watch when it's not their case? What do they need to do to make them feel comfortable? Help them write a letter. All those kinds of things are so important. Okay. Now, reasonable efforts. As we think of that as being the core, often from an advocacy perspective of the permanency hearing, I don't think so. I think the core is the case plan. Okay, but I put up reasonable efforts just so that you could write something down. Okay. So these are your questions as an attorney, and as a social worker, you're going to be asking these already, hopefully, along the way, because your case plan has been evolving. And we want to make sure that the judge has all the relevant information. The judge has to make a really important decision, okay? And hopefully not after a 15-minute so-called hearing. So, and does the judge have all the information? The key question, I should have put that number 1, but I know we've all figured that out. Is there a nexus between the services and or the case plan and the parent's behavior and the underlying problems that cause removal? The standard for reunification, whether you're looking at the 6-month hearing or this hearing I submit to you, is the same standard as what was used and what we must use at the time of making the removal decision. It is the same standard. Would it be unsafe to return this child to this home, to this parent or parents, under the conditions as we know them now? We don't have a crystal ball. We do the best we can. We do not have a crystal ball. Sometimes we don't even believe that people can change. I have a tendency to believe that that's exactly the opposite. But what we do is we have that snapshot and what we've learned through good communication, involvement, engagement, watching, observation, input over the past 12 months. Okay? But the key in reasonable efforts is whether that nexus exists. Efforts cannot be reasonable, in my opinion, if that nexus does not exist. They can be nice, they can be helpful, but they're not reasonable if they're not designed to remediate the reasons for removal, and if, as a result of all the information that's been gathered about what the parents have done, the relationship with the children, there is not evidence that there is that child is now safe to be returned or not safe to be returned, then you don't have reasonable efforts. We have a compliance checklist, and that's not what parents are entitled to, and that's not what benefits children. Okay. Judicial oversight. Okay, what doesn't work? Obstacles to permanency. We talked about cookie cutters. Continuances. Okay, county attorney, you want a continuance, any objection? Parents, attorneys, no. Okay. the parent's attorney comes in and says, I want a continuance, and the judge says, they wanted a county attorney, now your turn. I know that doesn't happen in Nebraska, but it shouldn't happen anywhere, okay? Services need to be front-loaded and need to be linked to safety. The invisible family, the paternal side, you're going to have a lot of sessions on that today, materials as I spoke to before. Compelling reasons. Are there really compelling reasons? Adoption is the preferred, if not reunification, plan for youngsters. Because not just because you want to be mean, but actually because there's research about well-being that relates to adoption. Okay? So are the compelling reasons really compelling? That's a discrete, I think highly complex analysis that needs to go on at that permanency hearing if it's not going to TPR. And that is something that I think is under-advocated and frankly under-prepared from the agency attorney or county attorney or district attorney side. So I really suggest that judges really focus on that, and as a practice corner, everybody needs to. I like that, the role of your judge, consult with the child, we talked about that. Remove obstacles, ICPC. The social workers are required to look at placement outside of borders. Judges are required to remove obstacles insofar as they can. Attorneys have to know what the ICPC is. Right? If everybody complains about Regulation 7, it's because it's underused, in my opinion. What doesn't work? Okay, let's look at what does work. Front-loading services. As an attorney for a parent, get your client those services now. Make sure they're linked, object if they're not, linked to safety reasons. Get an early assessment and a thorough family assessment of the extended family. Okay, don't lose anybody who is collected early on. Involve the extended family. Specially trained personnel working on locating family connections through electronic databases. The Family Find model has had tremendous results nationally. We can find our high school sweetheart, my first grade teacher. That's too far, but you know what I'm talking about. Somebody has found you. Look at this Facebook stuff. I have a couple of clippings, I've been keeping them, on how many people have connected through Facebook to parents when they were adopted, when they were infants. It's just incredible. So if your agency is not using that, or you are not using that to help your clients, then you're missing a wonderful opportunity. A key to what works is well-trained attorneys with zealous advocacy who can communicate